Hello and welcome to our Stepping Stones podcast, supporting Americans with each step of their unique journey in the UK. I'm your host today, and my name is Carlo Gray. I'm a partner at Buzzacott and I'm joined by
Sarah Whitelaw, partner in Buzzacott's Expatriate Tax Services.
Rachel O'Donoghue, I head up the financial planning team at Buzzacott.
I'm Will McFarlane, I'm a partner in the family team at Kingsley Napley.
Excellent. In this episode, we'll discuss marriage and divorce. And to get started, let's share the story of our clients Monica and Charlie. Monica is a US citizen, and Charlie is a British citizen, and they've been living here in the UK for nearly 4 years. They recently got engaged and are seeking some joined up tax, financial planning and legal advice so that they're aware of the implications of marriage and any planning that they should consider before marriage. Monica comes from a wealthy family and has significant investments in the US in her own name. Charlie has recently inherited some money from his parents but has no other sources of wealth. So step one, pre-marriage planning. Will, if I can start with you, in this situation, what would you advise?
I suppose much of this will depend on whether you're advising Monica or Charlie, because it's not a terribly romantic thing to say, but if you're advising the financially stronger party, the advice might even be perhaps don't get married and live together, cohabit. The financial position, if the relationship were to break down, is wildly different if somebody is cohabiting or if they're married. There is this almost rather common law marriage myth in this jurisdiction where people think, if we live together, we have children, it's as good as being married, isn't it? And the answer is very definitely not. If your relationship were to break down and you're cohabiting, you're reliant on a rather complex mix of trust law and property law, and it can lead to some very unfair outcomes. Whereas if they do get married, this is a very generous jurisdiction where if the marriage lasts for any significant period of time, the starting position is an equal division of capital. You can share pensions and receive maintenance or alimony, as most US people would see it, for quite significant lengths of time. So the position is very different. And I think in this situation, if you were advising Monica, step one might say, are you sure you want to get married? That's what I think of to start with.
And Rachel, from a financial planning perspective, what would you recommend?
I'm probably more of a romantic than Will. It's a fair point, I think, that you make, Will, in terms of, again, depending on who's the person coming for the advice. And also, clearly, Monica in this situation is the wealthier one. But in general, particularly if there's what we call, I suppose, a mixed marriage, as in British citizen and US citizen, being married definitely gives more opportunities. So it's not just a nice day out. It also means, from an investment point of view, we don't particularly just have to look at one individual. Again, possibly more for after marriage, but at the moment Monica has investments in her own name, and it's something we come across a lot, particularly here at Buzzacott, and I'm sure you do, Will, that people often move to the UK with investments that, once they're in the UK for a period of time, may not work from an investment and tax perspective. So we'd certainly want to look at that. It's not directly linked to the marriage, but we'd certainly want to look to see, are these going to be appropriate if, by the sounds of it, they're staying in the UK longer term. So that's probably the initial side, and obviously making sure I got an invite to the wedding.
And Sarah, from a tax planning perspective, what would you recommend?
Yeah, I mean, tax probably isn't the first thing that springs to mind when they got engaged, but I think it's sensible for them to consider a few things just in advance of actually getting married. For Monica, she's been filing US tax returns as a US citizen using a single filing status. So she's reporting her income only on that return. For US purposes, once you're married, you do have the option to file jointly in the US. But because Charlie's not a US citizen, I don't think that it would probably be beneficial for them to file jointly. So she'll probably just end up filing separately to exclude his sources of income from US tax. There are some scenarios where it could be beneficial to file jointly, and there is an election available there if they choose to do that later down the line. But I think married filing separately is a slight change to filing as single. There are some limitations on credits that can be claimed, but it's just what the default position will be once they're married. And future, down the line, if they have children, there may be options to use a head of household filing status, which is more beneficial than a married filing separate filing status in terms of tax bands. So there's options along the way, and I think it's worth highlighting that to Monica at this time. The other thing is transfer taxes, so sort of gifting between a married couple. For UK tax purposes, that can occur at a nil gain, nil loss rate, so not really any implications. And that's quite handy because it can help with tax planning to utilise lower tax bands in the UK, particularly for Charlie if he's the one that perhaps doesn't have as much income. For US tax purposes, gifting, so if Monica's gifting to Charlie, she's going to be limited to the non-resident alien gifting exemption, which is $175,000 currently. So that's worth bearing in mind, just because we've got the situation here where they're not both US citizens. The other thing that they might consider is buying a property here in the UK. And it's common from a UK tax perspective for married couples to buy a property as joint tenants with rights of survivorship. That's sort of a 50-50 ownership of the property. It may not suit Monica and Charlie to do that because of the fact he's not an American. The US isn't as generous on the sale of the home as the UK, so there's no complete exemption under PPR relief. So it may make sense to have a tenants in common ownership of the property where Monica has a small percentage share in that property.
That's a good idea. Yeah, excellent. And Will, if I can come back to you. So where we've got clients that have got assets in the UK and the US, I know sometimes lawyers get the question of do we need a US will, do we need a UK will? But in a prenup situation, do they need a US prenup and a UK prenup?
I think it really depends on a range of factors. Typical lawyer answer, it depends. We would look at issues such as where are the majority of the assets, where do the parties intend to spend their time, right. Because the second of those things frequently determines where any potential divorce proceedings might take place and financial proceedings. But in broad terms, looking at this situation, if I were advising Monica, it looks as though she's likely to be the financially stronger party and looking to protect significant assets in the US. And one of the quite positive things about looking at prenuptial agreements in the context of England and Wales and most of the US individual states is that the jurisdictions fit quite well together when you're preparing prenuptial agreements because on the whole they're both common law jurisdictions, and in this situation we'd probably look at doing a US agreement. This scenario doesn't say which state Monica is from, but on the whole with most of the common ones, so that we deal with, so New York, California, Massachusetts, Florida, it's fairly easy to anglicise a US agreement by putting in terms that are familiar to UK courts, English courts, so that if a divorce were to take place here, it would look very familiar to an English judge and they'd be likely to give it very significant weight. So it depends, but in this situation, I wouldn't be surprised if we were to do a US agreement and anglicise it.
Right.
So often we get clients coming in the door, often US clients saying, well, prenuptial agreements, they're not binding in England, are they? They're completely ignored. And the answer to that is usually not what they'd expect. Sure, the government hasn't legislated to make them binding, but since 2010, where we had the Supreme Court's judgment in Radmacher, it changed everything. So from then onwards, really, if you enter into a prenuptial agreement properly, you can't sign it with your fingers sort of crossed behind your back. You're highly likely to be held to its terms. What do I mean by properly? I mean both sides need to have independent legal advice. There needs to be an exchange of financial disclosure. There can't be duress applied by one party to the other. So you can't hand an agreement to your fiancé and say, look, sign this or we're not getting married tomorrow. And it can't leave the financially weaker party in what the court would describe as a predicament of real need. So if they can't house themselves, if it's manifestly unfair, then certainly the English court is likely to go behind it. But if it's done properly, whether you're a US citizen, whether you're from wherever, they are likely to carry very significant weight, and that's the direction of travel, even if the government hasn't legislated yet.
Step 2, marriage. Monica and Charlie have been happily married for 2 years now and have twin boys. They own a property in London and have recently purchased a holiday house in Florida. Rachel, if we start with you this time. So they're married, they've got young children. How does that change things from a financial planning perspective?
Well, in short, it gives a lot more options. Again, it depends how couples plan, whether they're married or they're cohabitating. If they're looking at their household and the income and their future income as a whole, some couples are less keen than others to do that. But in general, when we're sitting down with clients, if we're looking at, well, what's the long-term objective? Where do you see yourselves being? What type of income do you need to live on? What assets do you already have? If you're given a reasonably open mandate, we'd be looking at something for Monica and Charlie where we'd see, well, now we have the option of having investments, for example, or pensions in Charlie's name. In the past, clearly, if they weren't married, you wouldn't necessarily be looking at transferring monies or assets between them. But if you're looking at and saying that Monica is reasonably wealthy in her own right, and they want to have, for example, a certain level of income in retirement, or they want to fund maybe education, for instance, or buy another property in the future, we would take a step back and say, what do you have now, and who is best to hold that? And in many cases, it may be that holding it at least partly in Charlie's name will give them a lot more options, and in net terms will cost them less in tax. It will certainly open up the investment options. So even though we work, as you know, with a lot of clients that are US citizens here in London that have restrictions on investment options, there are some available, certainly. Yeah. But clearly they're more if it's a British citizen with no other restrictions. So mixed marriages, as I call them, give a lot of flexibility as long as a couple is happy to look at the household income. And clearly, even though US citizens can consider pensions, again, more straightforward for UK citizens like Charlie, so we'd certainly look at that. And the twins, again, and Sarah may want to touch on this, that can bring complexities depending on if they have dual citizenship, and if we were looking at investments, then ordinarily we might look at, for children here in the UK, we sometimes have to be a bit more careful if the US is there in the background as well. But overall, very positive, lovely day at the wedding. And now we can make their lives a lot easier, really, but there still needs to be careful planning on the Monica side in terms of the US, but we've got more options now.
Yeah. And then Sarah, leading on to the tax planning for a married couple with young children, remembering that Monica's a US citizen and Charlie's a British citizen. Tell us what that means from a tax perspective.
Yeah, I mean, I think it lots of this links very closely with what Rachel's saying on the financial planning side. We've got assets and investments in both countries, and we've got both tax jurisdictions in play for Monica and Charlie. The point you raised about, utilising Charlie's lower rate bands in the UK, it is key because that's going to probably bring down their global tax liability overall, because the UK tax rates do tend to be higher than the US rates. I think you alluded to it and I alluded to it earlier, but having Charlie owning the UK home is probably quite a good idea. The reason being that if Monica owns the property and they realise a sizable gain in dollars on disposal of the property, then the gain is going to be taxed in the US to the extent it exceeds $250,000. So that really is one of the big mismatches between the two tax systems. The Florida holiday home, perhaps it's best for Monica to hold that in her name. I think doing that prevents exposure for Charlie on potential rental income in the US, capital gains if that property is sold, and also estate tax from a US tax perspective, because his US estate tax threshold is very low at just $60,000. In terms of sort of ongoing tax and filings, Monica as a non-domiciled individual, has the option to claim the remittance basis in the UK. So to the extent that she has income that's arising outside the UK and that's sizable, it might make sense for her to claim the remittance basis, and also perhaps in future years pay the remittance basis charge. It's something that we would just look at year on year to see what was best for her. Timing of tax payments is key for Monica now that she's in the UK and has been for a while, to make sure she has the foreign tax credit in the right place at the right time. And also, if she stays here long term, then deemed domiciled will become an issue for her, so bringing her worldwide assets into the scope of inheritance tax.
Fantastic. And Will, now that Monica and Charlie are married with young children, what would you recommend from a legal perspective?
I suppose, to add to what you said, it's always, as a family lawyer, to put a spanner in the works. It's rare that tax efficiency and efficient tax planning sits comfortably with wealth protection. Quite often where the people sitting there saying, no, please don't do that, because if this marriage were to break down. So I think really the main message is just to make sure that it's the advice is coordinated, potentially with a family lawyer as well, to look at the wealth protection angle, to make sure that while they're being as tax efficient as possible, they're not inadvertently putting assets in the firing line. So, for example, settling a trust of which both parties are beneficiaries. And I know there are US-UK issues with that, but in simple terms, if that's done, it's very likely that the trust would be seen as nuptial by a family judge. I'm not going to go into exactly what that means, but the implications of that are that the family court on a potential divorce could vary the terms of the trust to appoint capital to the other party, make distributions, etc. So just things like that to keep in mind, but hopefully it wouldn't blunt the tax efficiency that you would be putting in place, Sarah. Yeah.
Okay.
And what about wills? And now that the couple are married, what would you recommend there?
Always important to have a will, and if they're buying UK real estate, it's important that Monica has a UK will. Charlie should do so anyway. I'm a family lawyer, so it's not particularly my practice area, but that's certainly my understanding. And also, as soon as they get married, if either of them or both of them had existing wills, that would be revoked by the fact that they've got married. So very important to do a general review of their estate planning on both sides of the Atlantic, really.
And perhaps thinking about guardians for the young children as well is always a sensible point.
Yeah.
I suppose the tricky thing with all of this, Carlo, is that you're giving legal or financial planning or tax advice, and there's also, I suppose, the personal aspect or that more emotional attachment. What we've talked about property, for instance, or assets. In reality, even though it might be tax efficient for one person to hold a house or a small portion, some people, certainly in my experience, feel quite strongly that certain assets should be retained in their name, and that's the challenging part, I think.
Yeah.
And spending time, as you say, between different advisors, getting that right, because there's no one solution really.
That's a very good point. Step 3, divorce. Unfortunately, after many years, Monica and Charlie's marriage didn't work out, and they're looking to file for divorce. Monica is considering moving back to the US with the children. Will, if I start with you, perhaps you can tell us the process. If couple come to see you, or Monica or Charlie, what would you advise?
Yeah, I think usually it would be one of them rather than together. And I think the first thing I'd say is to really think about things carefully and perhaps take your time. I think sometimes there's a real pressure on people to feel as though they're doing something and taking steps if their marriage has broken down. And I think the most important thing I'd say is the steps that they take at this stage, whether you're Monica, whether you're Charlie, they can affect the whole course of the likely outcome, how long it might take, whether it's plastered all over the newspapers. I don't know if they're in the public eye, but it really can make a massive difference. So I suppose the first thing we would think about is where the proceedings could take place, so jurisdiction. That's loosely based, well, not loosely, it's based on really residence or habitual residence. So that's a bit of a centre of life test. So where people live, where they go to the doctor, where they're registered with various things, where the kids go to school in this situation. And also domicile, which is essentially nationality. It's based on where domicile of origin, where somebody's father was born, which sounds rather old-fashioned in this day and age, or you can acquire a domicile of choice, but I'm not going to go into that now. But we look at those two things. In terms of establishing jurisdiction here in England, in this situation, if Monica and Charlie have been living here, even if Monica has already moved back to the US, the English court is highly likely to be able to deal with divorce and financial proceedings, and it's possible that whichever US state could as well, but it's something we'd need to look at very quickly. And at that stage, it's really important to, once you've established which jurisdictions could deal with the proceedings, what does the outcome look like? And that will depend on whether you're acting for Monica or whether you're acting for Charlie, because this is the most generous jurisdiction in the world here. London, it's no coincidence that London's often described as the divorce capital of the world. It's because it's so generous to financially weaker parties, whereas some US states will be less generous. And so it's important to check the position in those other jurisdictions. There is an organisation called the International Academy of Family Lawyers, which has an excellent website. And you can put in the relevant US state and it'll list relevant attorneys who can advise in that jurisdiction. And certainly if clients come to see us, we would check the position if the proceedings could take place elsewhere to see whether your client is going to do better if proceedings take place here, or perhaps less favourably if the proceedings took place elsewhere. And sometimes it's quite pressured. You might give the names for a conflict check for a lawyer in that jurisdiction. And I had this the other day with a particular state in the Midwest, and they said no, they couldn't act. So we were very quick to get advice from someone else to make sure that we had the advice in place and deciding where to issue proceedings, which in that situation we started proceedings here. It's not necessarily determinative who goes first if there's what we call a forum dispute between parallel proceedings, but it's certainly one of the things that the court would look at. But one of the other things, not only in terms of what a judge might do, we think about in that context is where it would be most tax efficient for the proceedings to take place, and how that would play out for your client. And almost always it's important to get someone like Sarah or you involved immediately, and Rachel, so that we can factor that in and make sure that you start proceedings in the right place.
Yeah, definitely. Well, I think you and I have worked together before to sort of look at tax liabilities on potential divorce settlements. There's some key principles that apply for US and UK tax purposes, sort of trying to do the same thing but slightly different as well. So I'll just run through those quickly. For US tax purposes, transfers to former spouses can occur at nil gain, nil loss, so long as they're incident to a divorce. Incident to a divorce is defined as a transfer that occurs within 1 year of the marriage ending or within 6 years pursuant to a written divorce agreement. So in that situation, we're talking about two US citizen spouses. If there's a US citizen spouse married to a non-citizen, then transfers from the US citizen spouse to the non-American will be treated as a deemed disposal, so there's a capital gains tax charge there. For UK tax purposes, again, transfers will occur at nil gain, nil loss, so long as they occur within 3 years after the year that the couple cease living together, or any amount of time if under a written divorce agreement. And I think even though there might not be any tax liability on particular transfers, it's always important to get the tax liabilities worked out at the time of transfer, so that can be factored in to the divorce agreement. In the situation of Monica and Charlie, the sale of the UK matrimonial home as a result of divorce proceedings obviously needs to be considered. Is there a tax liability? We would hope not, on the basis that perhaps Charlie has owned the property in his sole name. Will, you can correct me if I'm wrong with your planning there, but ideally there wouldn't be a charge to tax on the sale of it because we would have structured it well up front. And there would also be no exposure on a redemption of a foreign mortgage, which can cause issues from a US tax perspective. With regards to investments, and Rachel, you'll probably have some thoughts here on the investments as well, but I think, as I mentioned previously, the transfer of any investments from Monica to Charlie need to be considered carefully, because that could be a disposal if there's a gain in dollars, and also if there are offshore monies that Monica has and that she's protected by claiming the remittance basis in any year, we don't want to sort of create a remittance issue on a transfer to Charlie at that time. Have you got other thoughts there to add?
I think it's also, I mean, we touched it maybe earlier, in that if the investments weren't US and UK tax efficient already, something like this, might bring that to the fore as well. Particularly, as you said, if it was being transferred to Charlie. So ideally, you'd have done the planning beforehand, and you'd have looked to see that everything was US and UK efficient, and that Monica held the investments potentially in the US, but they also had similar UK treatment. But as you said, the foreign exchange side of things, it can often be something that I think just gets forgotten about until you actually start doing these calculations. And the key bit, as you alluded to, is doing that early on, because often people are so focused, and I think you were saying the same, well, trying to move ahead very quickly, when actually taking a step back and saying, well, what are you trying to achieve, and looking at in detail first, really, rather than just afterwards saying, here's what the tax bill is going to be. It's trying to get us involved early on, isn't it?
Yeah.
I mean, I think in terms of investments overall and pensions otherwise, I mean, most people will be aware that whether it's UK or US, obviously, Monica or Charlie, it isn't mentioned, we haven't talked about it here, but typically might have pensions as well. And that's often where you see things like pension sharing orders and splitting of different assets. I suppose the key thing we would say is that if we are involved early on, and particularly it's easier said than done, but if there's a reasonably amicable divorce or it's collaborative, and you're trying to get to the position where each person has a certain level of assets or a certain level of future income, that we can get involved in from a US and a UK point of view. We can look at what the overall financial plan is, what we're trying to achieve, because sometimes people will often split assets, and it's often driven maybe by emotion, when actually certain assets, particularly UK side assets, may make sense to be with Charlie. US if it's with Monica, particularly if she's going to go back to the US. So sometimes when I deal with clients, it's often maybe where people have gone through a divorce and it's at the stage where they're saying, I've been given a certain lump sum or a proposed lump sum, which is fine, and obviously we can advise on that. But it's often quite a bit on in the process, and at that stage then we've sometimes looked at it and said, well, actually we've done some cash flow modelling, we've taken into account your situation, your future income needs, your attitude to risk, etc. And actually, I'm not sure it's going to produce the level of income you require, which that's fine and that's helpful, but that would probably be something early on in the process would work better in it. But I think maybe the perception sometimes is having different people involved can add to the cost, when actually I would argue that if anything, it probably saves time and money to get the experts around the table as early as possible, really. And then everybody's hopefully on the same page. May not agree on everything, but they have a clear picture of what the financial plan is.
I think pensions, what you said about that's jogged my memory, that frequently we have situations where it's not the Monica and Charlie situation, but when two UK nationals move to the US and they have big final salary pensions here, and they start divorce proceedings in the US, whichever state it is, and they then find out that an English pension scheme will just ignore anything and probably not implement anything that's included in a US court order. Yeah. So we frequently deal with a situation where either the funds are offset, so one party will keep the pension and then there's an adjustment in the US assets, or if the pensions really do need to be shared, we can do pension sharing here under what we call Part 3 of the 1984 Act, the Matrimonial and Family Proceedings Act 1984. I won't bore you with all of the details of that, but it's a really helpful tool to share English or UK pensions after a divorce in the US, and you just record in the US order what has been agreed, and then you could just make an application by consent here. And we're finding that increasingly that we're doing that for UK nationals in the US.
I think the pension side, particularly even outside of divorce, has become really complex in recent years, but even within divorce, and as you said, particularly if you're looking at defined benefit or follow-on salary pensions, often through no fault of their own, people don't necessarily recognise what the value is, what the implications are around things like lifetime allowance and that. And we've seen some situations with clients we've had here at Buzzacott where people have been given a sharing order, it's being moved into a UK pension, but with a US citizen as the owner of it, and not always maybe structured in the way that we would have recommended if we were looking at it from outset. So it's trying to get into that detail, I think, early on, isn't it, so that you hopefully get the best outcome overall.
And Will, just coming back to you, Monica is considering moving back to the US with the children. Talk us about the impact for the children on
Yeah,
that.
I mean, again, she needs to think really carefully about that, because in this situation, both her and Charlie have what we would describe as parental responsibility. So they both have to agree all of the big ticket decisions: where they go to school, where they live, how they're brought up in as a Christian, as a Buddhist, as an atheist, all of those things. But that includes where they live. And if Monica were just to simply go to Heathrow and go back to the US with the kids, that would be child abduction.
Right.
Charlie could make what we call a Hague 1980 application for them to be returned. So this either has to be agreed, or if it's not agreed, she's going to need to make an application. We refer to them as leave to remove or relocation applications to get permission from the court. That's because the kids are habitually resident here. I've talked about that earlier on. The centre of their life is here. They go to school here. They live here. So the English court can deal with any welfare considerations about that. And it would be up to Monica to really think carefully and set out a plan showing where they would live, what are the support networks. And the court looks at a welfare checklist, so the wishes and feelings of the child, the physical, emotional, educational needs, all of the likely effect of the change of circumstances, those sorts of things. So she would need to think very carefully about whether it's in their best interest and it's not just about her, and setting it all out. And Charlie would be, no doubt, presenting an alternative view as to why, London or the UK or England, that is the place for them. And these are really tricky cases because it's such a binary outcome. It can be heartbreaking, whichever side you're on. But either way, ideally that would be agreed. And if those things are agreed or ordered, what would often happen would be that during the school term time academic year, the kids would spend would be based with Monica if she got permission to relocate, and they'd spent very, very significant time with Charlie in the school holidays, sort of to try and balance it out. But they're really difficult cases and often quite finely balanced.
Very helpful. We focused today on Monica being a US person and Charlie being a Brit, and we've talked about how each of you can help them. Tell us about the value that you could each add in this situation with working together for the benefit of the couple. Will?
I think when a relationship breaks down, which often that's what I'm dealing with my side of this, it's often quite an emotionally charged situation. Things are often quite fraught when a client comes to see you. And I think the main message that I would have is get advice early and take your time in really thinking about it rather than rushing down a particular road. And when I say get advice early, I don't just mean come to Kingsley Napley and get some family law advice. I think it's really important that the tax considerations are taken into account, that financial planning situation is also taken into account, so that everything is factored in before that person decides to take a particular path from that crossroads. Because otherwise you're taking all sorts of decisions before you even take advice. And from a family law perspective, we're having to clean up some mess from perhaps not making the right decision. And from what Rachel has said very clearly today, it's the same. She probably wouldn't have advised to do certain things. So get advice early and try and take your time, no matter how fraught things are, to get it right at the start.
Rachel?
I probably echo quite a bit of what you said. I guess in particular, not just for Monica and Charlie, but situations like this where there's a US or some kind of non-dom element, it is more complex, frankly. It's obviously an area that we as a firm and will specialise in, but it does add that layer of complexity. But again, it is back to the basics of these times do tend to be emotionally fraught. It's actually looking at it and saying, well, if we can get the figures, the legal side of it there, so that everybody has a clear plan before key decisions are made, that can make a big difference. And the clients I've worked with where there are US elements to it, it has that layer of complexity which we are used to, so hopefully we take away some of the pain of that. And I think that's, wrongly rightly, still quite unusual even here in London. But it does mean we can add a lot of value, again, if we're included earlier on. And I've certainly seen with cash flows as an example, it's one that's very good at taking some of that emotion away, where it's an external person, which can be used by both parties if need be, where you can actually show data and you can give background to it rather than it being about an asset or what somebody has, or I suppose the more fraud discussions around maybe where the children live and education.
Yeah.
So it's trying to break it down and saying, well, let's do what we can to make this as, it's never an easy process, but certainly not any more difficult than it has to be.
And Sarah?
Yeah, I think you mentioned that we focused today on Monica and Charlie, you know, the mixed marriage, a US citizen married to a Brit, but I think, you know, obviously all of us advise other types of clients. So it may be a US citizen married to a US citizen, it may be a US citizen married to not a UK citizen, some other jurisdiction. And we've got links there. Will, you mentioned earlier that the international group that you can reach out to for advice in other jurisdictions, and we've got Prime Global as well here at Buzzacott. So to the extent that accountancy or tax advice is needed in another jurisdiction, then we can reach out for help there. But yeah, you know, getting advice early and in advance of any significant life event, really, it doesn't just have to be marriage or divorce, is definitely key.
Thanks to our speakers for joining us today, and thank you to our listeners for tuning in. Plan your next step by looking at our other episodes in the Stepping Stones series, including and covering business, property and investments, and much, much more. Thank you very much.
Thank you.
Thank you.